Mr. Hull, may I hear from you, please?
Thanks.
Should I be turning up the factum?
You can wait for my direction, thank you, Your Eminence. I'm going to be speaking to the audience because that is what I believe is the audience of the day today for me to concern myself with. I want to start with the relief sought, and I ask the audience to consider, of course, the relief sought, which is set out of tab 4A, and the focus with respect to this matter is, as has been identified at the outset, as to whether or not the provision, the disinheritance clause of the will, which disinherits Howard Shapiro if he marries outside the Jewish faith, is unenforceable. And I think, as my dad taught me many years ago, we have to talk like lawyers. We cannot get caught up in what is an emotional and sometimes non-legal driven issue. And to do that, the courts have said two things. If a clause is enforceable, there are two steps to undertake. The first step, and the most important step, is to read the will. In the will...
Sorry, I didn't catch that.
Sorry, I didn't know you were here. Read...
Manishtana Halila has
See, there's a lot of stuff being said that's not fair, okay? You guys have to start talking slow in those things. What did you just say to me?
I'll translate. I'll tell you later.
All right. Read the will. And the will is paramount in every matter of interpretation, which, although we want to characterize, and my friends will want to characterize at very high hourly rates, the emotional side of this debate. The debate comes down to what the courts can only do. We can only do so much. And again, as it's something my father taught me a long time ago, is that we don't have the right caller to fix all of the problems. And my friends are going to rely on a caller that they don't have either to sustain an argument that doesn't have any sustainability at law. So we look at the will, and to read the will, we look at just the first part of the clause. I bequeath all of the residue of my estate into 2 equal shares, 1 share to my son Howard, and the other equal share to my son, to Janet, provided that each child should receive his or her respective share of the bequest only if she is married at the time, or he or she is married at the time of my death to a Jewish spouse. Goes on to define Jewish spouse, and it goes on to have an arbitration clause if the definition is getting unwieldy. That is what the will says. There are 2 elements to that now. Is it a valid condition?
Excuse me, I'm just being arrested here. Hang on.
It's long overdue. Is it a valid condition, A? And B, is it void for public policy?
Just 1 second, Counsel. I just want to read out a couple of license plates that are parked in the wrong spot.
Okay, this isn't cutting into my time.
No, don't worry. AFLC 704. Is that a B? 672 PSF. You got to move your cars. Please. Thank you. Is that anyone here? You can sneak out the back. We won't look.
All right. Could I continue?
Yeah, keep going.
All right.
I'm loving it so far.
Sorry, I'm back here. So the focus is the 2-part analysis, and it is going to be the analysis in respect of any interpretation, which we are here to do today, and that is an interpretation of the clause. First, is it a lawful condition? Second of all, is it against public policy? The first element is, as I say, we look at the clause, and the case law says clearly that when we look at that clause, we determine whether or not it's a valid condition on a very principled basis. The first being which is that does the condition actually give a gift? Is there a gift that occurs? And that is almost always achieved with good drafting, and in this scenario we have good drafting. So then the question remains, if it's a valid gift that is actually fulfilled, in order for the beneficiary to receive that gift, that is, the they must marry out of they must not marry out of the Jewish faith. The defined term, and what all the materials refer to as, quote, the Jewish clause. Does that clause, does that condition, is it met and is it enforceable? The Clayton decision talks about a case where there was a Jewish clause was considered, and the court found in that case that the clause it lacked certainty for it to be enforceable. But an interesting obiter in the Clayton decision talks about the fact that the term, for example, the Christian faith, is a term that is understandable to the courts, and in the court, in the obiter, they go on to say, and so should the term Jewish faith be a term that is understandable to the court with certainty. It comes down to the clause itself, and as I took you carefully through the clause, this case, we have certainty in respect of the condition. So, if this is truly an interpretation case, then it helps us to look at some of the case law as well. The Peach Estate decision was a question of where it was a property that must be sold by it had to be, the clause provided that the property must be sold to an Anglican or Presbyterian. And again, the court struggled with whether or not that was definitive enough. Is it simply too vague to say that, and therefore, is it uncertain, and therefore, is it unenforceable? Well, the court talks about the balancing act between the necessity of testamentary freedom and avoiding an intestacy and all of those considerations. But the court says this: although there may be circumstances where it is difficult to determine whether a person satisfies the definition, such difficulty should not prevent giving, in effect, if possible, the testator's expressed intention. So we have this struggle, and it's a continuing struggle with every interpretation case, and that is that when we've got testamentary freedom balanced against another element, and our other element in this case happens to be public policy. But we don't have it balanced against uncertainty, and that is often the case when we're dealing with interpretations. So with respect to the Jewish clause, the Dobson estate tells us to go to the armchair rule. Look at the plain meaning of the word. Look at what Jewish faith is. As it is an ascertainable term, I pointed to the decisions that say the Christian faith is an ascertainable term, so should the Jewish clause be ascertainable, the Jewish faith, the term itself. And the Dobson case says, as we always do in interpretations, look at the surrounding circumstances, which we've already heard about, and I don't want to delve into. So if it's a valid condition and it's enforceable, then what are we missing? Well, what we're missing here is, of course, the possibility that this is against public policy. And so are we to uphold Jewish clauses in the context of public policy? Well, in that regard, we have two strong elements to the unequivocal answer, and that yes, these clauses can be upheld. We've heard from the rabbi. He said it better than I can in terms of the balancing act with regard to the social public policy. But then let's start talking like lawyers again. Feinberg, the decision in Feinberg, it's a U.S. appellate court decision from Illinois where Justice Gardner struggled with a case where the parents had put that no grandchild who marries outside of the Jewish faith will take. And in that decision, the appellate court upheld that clause and said that's a valid clause, and that the testamentary freedom element of the clause outweighed what may be perceived to be somehow some tension with regard to and I think the court obviously struggled with this, was the overstating the discriminatory element of the clause. Then there's the Barron-Cawley decision, where the court argued that, where it was argued that using public policy to make a void condition based on religion would be wrong. It would bring about a substantial reduction of what is most important, and that is the firmly rooted understanding in law that we have the right of testamentary freedom and testamentary disposition. My friends will focus on the Fox versus Fox decision, entirely distinguishable, not relevant in this case, and where that case was dealing with was an exercise of discretion that was set aside. The exercise of discretion was set aside as a result of the court finding malefides on the part of the fiduciary. So bad faith was undertaken on the part of the fiduciary. In this case, we're not talking about bad faith, and the courts talk about the struggle that it's not about one religion being better than the other religion. It is more about the enforceability of a condition that can be ascertained. And then finally, The key element to this argument is what the rabbi has articulated again better than I can. Survival is not an irrelevant factor here. Survival, this isn't, as I say, about one faith being better than the other faith. The Shapiro decision from the U.S. New England courts talk about a case where you must, again, the individuals had to marry within the faith. There was a gift over in that case to the state of Israel, and the court found that clause, the Jewish clause, again, enforceable. But what they did was they focused on and demonstrated the testator's conviction as a result of his concern about the survival of the Jewish faith, demonstrated in that case, of course, by the gift over. Because if his children married out of the faith, the gift over provided that it would go to the state of Israel. So this testator, and the decision was upheld, the Jewish clause was upheld in that sense because of that conviction. The data simply supports the survival motivation, and that the survival motivation in my submission is not something that can be underestimated in the context of the public policy arguments. Previous generations saw firsthand through the Holocaust how important survival is with the Jewish faith. Well, this generation hasn't got that immediacy. And what's happening is from the data, and this is not my theories, these are the data from two learned articles by Gustav Goldman, Intermarriage Among Jews in Canada, and Gordon and Horowitz's this article on Will Your Grandchild Be Jews? And both of those articles point to the data, and that is that we are faced with a statistical likelihood of the Jewish faith being eliminated from a data standpoint alone. And that, in and of itself, brings out its other element of the survival argument and the importance of it. And in conclusion, what would we do without the Jewish faith? Well, we wouldn't have Albert Einstein. We wouldn't have Sigmund Freud. We wouldn't have Christopher Columbus, so I'm told by the internet. But most importantly, we wouldn't have meaningful assessment of what are relatively complex interpretation clauses, and that is, this is not something that the courts are afraid of. They've been interpreting clauses of this nature for 600 years. If there's a valid condition, if the condition can be met with certainty, that is the Jewish faith, and that it isn't against public policy for the reasons that I've said, then this clause must prevail out of the obligation of this court. Now you can listen to me. So thank you very much for taking your time, Your Eminence. I know that you probably fell asleep halfway through it, no doubt, but I appreciate it.
Thank you, Mr. Hall. I have a few questions.
Me?
Yes.
My throat's sore. What do you want to know?
Tell me about that Fox case. You lost that one, didn't you?
Yeah. Yes. I take with great pride the many cases I have lost. And we do not have enough time for me to list them all.
All right.
But the Fox case, the interesting thing about the Fox case was that moment when my father stood up and his panel was on the left side, eminent Jewish judge, eminent Catholic judge, and in the middle, Justice McKinley, and it was the Catholic that rode him over like a truck. So we've always enjoyed that decision. So do you have any other questions?
I don't have any more questions. Since you're my landlord, I don't have any other questions.
Thank you.
I must confess that we did have ex parte discussions on this case beforehand, so.